Hello, I'm Adam Kielich, the principal attorney at the Kielich Law Firm in Bedford, Texas, where I help clients in the Dallas and Fort Worth area with their family law, employment law, and consumer law needs. Today's video is going to answer 7 common questions about qualified domestic relations orders, or QDROs. QDROs seem to be complicated and confusing types of court orders, so there are a lot of questions that I see over and over again about some of the basic issues with QDROs, so I thought an additional video addressing some of those questions would be helpful. If you're looking for additional information about QDROs, there's more information on my website, and there's a link in the text below the video that you can click on to find some more information there. So before we hop into the 7 questions, I thought it made sense to just briefly explain a QDRO. Now, chances are, if you're listening to this video, you're already somewhat familiar with what a QDRO is, because it's just not the kind of thing that people go out and research for fun. But let's just make sure that everybody is on the same page with what a QDRO is before we start getting into those questions. So a qualified domestic relations order is a special kind of order that's ordered by a court to divide certain types of retirement plans as part of the property division in a divorce, or to pay child or spousal support in either a divorce or a child custody proceeding. The reason why a special kind of order, this QDRO, is necessary is because most employer-sponsored retirement plans, at least those offered by private employers, are governed by a federal law called the Employee Retirement Income Security Act, or ERISA. And ERISA preempts most types of court orders that issue or that order a plan administrator of these types of plans to make a distribution or in any other way change the rights that an employee or somebody else has under the plan. ERISA has what's called the anti-cutback rule, which says once you have a benefit accrued under a plan, it can't be taken away from you. And there are some other rules under ERISA that prohibit a plan administrator from taking away or reducing benefits or assigning those benefits to some other person other than the person that's entitled to those benefits under the plan rules. And so ERISA carves out this exception for property divisions in divorce, child support, and spousal support for these special kind of court orders to allow the retirement benefits to be assigned to another person, whether that's the spouse or the ex-spouse, or even to the child in child support cases. To qualify as a QDRO, the order must contain specific information and provide that information in specific kinds of ways to be qualified under ERISA and the plan rules to allow the plan administrator to assign some of those benefits to another person. If, for whatever reason, the court order cannot be qualified because it does not meet the requirements under ERISA, then the plan administrator can reject the order and refuse to follow it. In fact, the plan administrator must reject it and refuse to follow a court order, which is sort of a unique power for a private individual to have with regard to a court order. But nevertheless, federal law says they can get away with it, so they do. And so that's the purpose of a QDRO. In order dividing part of the retirement plan that does not meet ERISA requirements has no effect and will not cause any effect upon the benefits within the plan, at least as far as the plan benefits are concerned. Now, in a divorce, for example, where part of the 401k has been divided within the property division, the person who's supposed to get part of the 401k is still entitled to those benefits from their ex-spouse, but they have no power to go to the plan administrator and demand that the plan administrator divide the plan unless they have that domestic relations order that is then qualified by the plan administrator to get that job done. So that's a QDRO. That's the purpose of the QDRO. So now that we understand what this thing is and where it comes from, let's talk about some of these general issues that come up. So number one, should you use the employer's QDRO form? Oftentimes, employers will provide a model or a template QDRO that you can use, and it's sort of a fill-in-the-blank kind of form, and then you take it to the judge to sign. Whether or not you should use the employer's form is kind of a complicated question. It certainly seems easiest to use the employer's form rather than try to find your own form yourself or figure out what you need to do to draft it yourself. But an employer's form QDRO is not without problems. Sometimes the forms have multiple options in sections specifically discussing how benefits will be divided. And you still need to know which option to select and what happens when you select that option to make sure that, number one, the order can be qualified, and number two, that the order makes the division it's supposed to either properly divide the property for the property division in a divorce or to make payment of support for spousal support or child support. Beyond selecting just the right options, sometimes the language in those forms needs to be changed, or additional language needs to be added to the form to make sure that the form, to make sure that the QDRO does what it's supposed to do. It's important to understand that with those form QDROs, the purpose is really not to make your life easier. The purpose is to make the employer's life easier, or the plan administrator's life easier. By having that form document used, they already know that the language is qualified, that if an order comes in on their form, that they can approve it as long as the right options are selected. And so that makes their job easier reviewing the order, but it doesn't necessarily mean that the order does what it's supposed to for you. And so that's a problem. Sometimes plans have these like side benefits or payment options that are not included in the employer's form. And if you don't include these within the order yourself, then the order doesn't provide whatever those additional benefits are, or the other payment options, whatever it might be. The problem there is sometimes when plans have these sort of complicated payment options or like backup death benefits, not having that language can be very expensive to you. You may forego thousands of dollars or a payment option that would pay out more beneficially to you that could have financial implications to you. So should you use the employer's form? It's definitely better than trying to find some random form online or paying some website to construct something to you. But it doesn't mean that the employer's form itself is necessarily the right answer either. So I guess the answer to that question is maybe at your own risk. So our second question, can a retirement plan be divided without a QDRO? Well, if the plan is governed by ERISA, generally no. ERISA requires that QDRO for all the reasons we discussed beforehand in order to make that division. Now, there are some retirement plans that are not covered by ERISA. These include federal employee plans, military plans. Some state plans are covered by their own rules, or they may be covered by some components of ERISA, but not all of the components of ERISA, which is kind of complicated. Some private employer retirement plans or other kind of savings plans are not covered by ERISA. These include things like stock purchase plans or stock options. Excuse me, not stock purchase plans. Those often are ERISA plans. But stock options and stock grants are not ERISA plans. There are certain kinds of deferred compensation plans that apply to executives and salespeople that are not covered by ERISA, and other kinds of like bonuses and some severance plans are not ERISA plans. So you've got to know, if you're thinking, maybe I don't want a QDRO, or I don't want to deal with this QDRO, you first need to figure out whether this is a plan that is covered by ERISA that will require the QDRO, because if the plan requires it, you need to go get a QDRO. The exception there is, I guess, that if the plan participant has a withdrawal available to them at this time, they could take the withdrawal and pay it out instead of using this QDRO. That may work to save some money trying to sort out this QDRO nonsense, get the order drafted and qualified. But the problem is, if a participant takes out money, the participant is going to owe taxes, and if they're under the age of 59 and a half, they may pay a 10% penalty as well. That can be a pretty big hit for the participant, because they're going to pay out a good chunk of money in taxes, and the withdrawal amount is going to be added to their income for the year. It may have some pretty stiff tax consequences. So it's usually an option that I don't recommend, but if you're not the participant, if you're the recipient of part of the plan, you may not care whether the other person is paying taxes or not. But certainly if you are the plan participant, it's usually a much better idea just to go get a QDRO done. So in summary, if it's a plan covered by ERISA, you're pretty much going to have to get a QDRO unless you have this withdrawal option available, or you can pay the amount out from other assets that you have and settle up with your spouse or your ex-spouse in a different way. If the plan is not covered by ERISA, some plans will accept a QDRO, but other plans will just accept sufficient language in the divorce decree or a form or whatever. To that extent, I would say contact the plan administrator or the custodian for the account and ask them specifically what they need to get that done. Number 3, can a divorce decree be used instead of a QDRO? And the answer there is generally not. The plan administrator, as we discussed before, has to make sure that there are certain information, certain pieces of information, certain language within the order in order to be able to make that assignment of plan benefits to another party. Now, a divorce decree could include all of the requirements to be a QDRO itself, but in the vast majority of cases, a divorce decree does not contain enough information to be a QDRO, and that separate order is going to be necessary to get that done. But again, if you have a plan or some kind of a retirement account that's not covered by ERISA, the divorce decree may have enough language, or you may need the divorce decree plus a form or something signed by the parties to get that done and not need a QDRO. But if it's a type of plan that will require a QDRO, the divorce decree is only enough if it is itself a QDRO. Number 4, what if there's a distribution before the plan administrator receives the order and qualifies it as a QDRO? Well, if the money's not there, the plan administrator can't pay it. So it would be up to the alternate payee to go chase down the plan participant and get paid using a different mechanism under the state family law, or to reach some sort of agreement to get paid out. And to kind of expand on that, what happens sometimes is a couple are preparing to get divorced. One parent or one spouse files for divorce, serves the other party. The respondent, the person served, looks around and realizes they need to pay for an attorney. So they go cash out their 401k or go take a big chunk of money out of it to pay for their attorney. At the end of the divorce, the parties have agreed to divide the retirement plans, and the petitioner who filed for divorce then realizes that the money that they thought was there in the 401k is not there because the other person used it to pay for their attorney. Well, if there's a QDRO issued, the plan administrator can divide whatever assets are there if the QDRO provides for that. But as far as the money that's already been distributed, the plan administrator can't go get that money back, and the plan administrator is not responsible for getting that money back. It's going to be up to you to go back to court, ask the court to enforce the property division in the divorce decree, or use some other mechanism to try to chase that money back down. Number 5, who pays the taxes on the money paid out from a QDRO? And here, generally the alternate payee who receives money under the QDRO is going to be responsible for the taxes that are owed. When money is taken out of a retirement plan under a QDRO, the distribution is made under mostly the same rules as though the participant had taken it out, him or herself. So that means the money is going to be included as ordinary income, and the recipient of that money is going to pay ordinary income tax on that amount based upon the normal IRS tax code. The alternate payee is not going to pay that 10% early withdrawal penalty for taking the money out, so long as the money is taken out directly from the plan that received the QDRO. If the alternate payee rolls that money over into their own 401k or into an IRA, that early withdrawal penalty reapplies, and it would be owed if a distribution occurs that would trigger that penalty. Now, the exceptions to that rule that the alternate payee is going to pay the taxes, there's 2. One is, as we discussed before, if instead of a QDRO, the participant just takes a withdrawal and pays it out as cash to the alternate payee. If that happens, the participant is going to eat the taxes because he or she actually made the distribution rather than the other person. And second, if a QDRO is ordered for the payment of child support, the child is the alternate payee, but the participant in the plan pays the taxes for those distributions. And that's because child support is paid as an after-tax responsibility of the obligor, and so the same is going to hold true if that money is paid out of a 401k or some other retirement plan, because either the participant agreed to have it paid out that way or the participant had no other way to pay it out, and that's how the court chose to enforce its child support order. But outside of those child support situations and situations where no QDRO is used, if a QDRO is used, the alternate payee is going to pay the taxes. Number 6, what happens if no QDRO was drafted and ordered by the court before the participant dies? What happens here is sometimes retirement plans are divided in a divorce, but for whatever reason, the parties don't end up getting a QDRO, or the court issues the order, the plan administrator rejects it, says it doesn't meet the requirements, and the parties don't do anything to fix it. Time goes on, the alternate payee doesn't need the money right away, so the alternate payee decides they'll deal with it down the road, and then the participant dies. Well, the good news is the QDRO can still be issued and qualified by the plan administrator even though the participant has died. The reason for that is The property division was ordered when the participant was still alive, and so the death does not change that division of property, although the enforcement mechanism through the QDRO is issued after the death. Now, the qualification that I would make to that answer is by waiting for that QDRO to be issued after the participant has died, the alternate payee may be in a problematic situation where the participant has already started receiving benefits or took money out of the 401k and there's nothing there. A surviving spouse may now exist that has competing rights to certain benefits under the plan. These can create problems for qualifying the order and getting monies paid out to the alternate payee. Of course, in the case of a 401k, if the participant took the money out before they died, as we discussed before, if there's no money, the plan administrator has nothing to pay out. And so the alternate payee may be chasing around money that may or may not even exist anymore. So never the best idea to deal with the QDRO after the participant dies. Best time to get it done is while the divorce is ongoing, and just have the judge sign the QDRO at the same time as the divorce decree. All right, in our last question or issue, why the plan administrator charges processing fees to deal with the QDRO. So in what's called a defined contribution plan, which primarily is a 401k, a 403b, and an ESOP, these kind of plans where the participant makes specific contributions out of each paycheck into the plan. With these types of plans, the plan administrator is allowed to charge a reasonable processing fee and expenses to review the QDRO, qualify it, and then segregate the participant's benefits and assign them to the alternate payee. What's reasonable for the fees? It depends on what kind of work is actually done and whether that work or the cost for that work is itself reasonable. It seems like it would be very simple to get a QDRO processed by the alternate payee, but there's a fair amount of work that can be involved. Because we're dealing with a court order and the plan administrator's legal responsibility to the participant, a QDRO should be reviewed by the plan administrator's legal counsel. So of course, that's an attorney who needs to get paid. There may be accounting work involved to figure out what the alternate payee's benefit is and how to get that paid out. And then there's going to be work by whoever is the trustee for the 401k or whatever account, whatever type of plan it is, to actually go in and divide those assets and set up a new account. The actual fees that are charged by plans can vary widely. Some plans don't charge anything. I've seen some plans actually charge several $1,000s because there was a lot of work by the attorneys, because there was some kind of argument over whether the language in the order was valid or whether it should be qualified. And the plan administrators decided to charge back those attorney fees either to the participant or the alternate payee or both. Some of the larger providers that provide 401k services to plan administrators like Fidelity, T. Rowe Price, Prudential, they charge a flat fee that may be anywhere from $300 to $1,200. Normally those fees are by default divided between the participant and the alternate payee, but a QDRO can specify who pays those who pays those fees. So the plan administrator is allowed by law to charge reasonable fees for the work done. And so normally they do, because there are those actual costs involved in getting the QDRO processed and the benefits assigned to the alternate payee. So it's important when the QDRO is drafted that those fees are dealt with and somebody gets assigned responsibility to make payment of them. I normally like to assign that responsibility to whoever is not my client, but often we end up splitting the fees between the two parties equally just to make sure that everything is fair. But the plan administrator definitely allowed to charge the fees. They don't have to, but they are allowed to. So those are 7 common issues that come up with QDROs. I hope that information is useful. If one or more of these issues have been floating around in your head, I hope this at least starts to answer or starts to address those issues. Again, all of these issues are addressed on my website, so if you're still looking for information, that's a good place to continue your hunt and try to find the information you're looking for. But I think this is a good point to stop the video. As usual, I want to thank you for spending your time listening, and I hope that the information here was useful, and I'll see you next video. Thanks.